Ingamana ingarea, ingata wida pumanawa, ro rakatidama, tenakoto, tenatato katoa. My name is Harleen Hain, and it is my great pleasure to be here to welcome you to this inaugural professorial lecture for Professor Margaret Briggs. As I look out on the audience today, I see a number of our staff and students from around the university, as well as members of the general public, including members of our university council. I'm sure that, like me, many of you have had an incredibly busy day, and you are simply looking forward to spending an hour basking in the glory of the brilliance of Professor Margaret Briggs. And I'm sure that she is very much looking forward to giving her presentation. Now, whenever I introduce a new professor, I have to remind the audience that the rank of professor is the pinnacle of academic achievement at the University of Otago, and it is only achieved by a handful of people who demonstrate excellence in teaching, in research, and in service to the profession and to the community. Now, as you will soon learn from Margaret's lecture, she is an internationally recognized expert in criminal law and the law of relationship property. She is also a gifted teacher, and she provides outstanding service both to the University of Otago as well as to her profession. Her research is not only cutting edge, but it has also made an incredible contribution to the judiciary. Now, we've known these things about Margaret for a long time. But in order to promote her to professor, we also sought advice from international experts in her area of research. And when we did, we heard things like, Associate Professor Briggs writes superbly, even on difficult technical subjects. Her writing is always clear, economical, yet with a nice turn of phrase to make her point. It is actually rare that one finds such excellent writing, even amongst most very senior academics. We also heard about her outstanding scholarship. One of her referees said, Margaret Briggs demonstrates time and time again in her work on relationship property her command of history, legislative developments, policy issues underlying statutory interpretation, and judicial developments, all the while keeping a critical eye on the practical legal outcomes of her work. And on her career as a whole, we heard, this is the work of a mature, self-assured scholar, sustained at an outstanding level over many, many years. Internationally, she is well recognized as an expert in her field. Well, all of these comments simply confirmed what we already knew about Margaret. So, Professor Briggs, on behalf of the University of Otago, I would like to warmly welcome you to give your inaugural professorial lecture and to congratulate you on your very well-earned profession. But before I give you the opportunity to speak, I will first call on the Dean of the Law School, Professor Mark Hennigan, who's going to tell us just a little bit more about your journey to professor here at the University of Otago. Nō reira, tenakoto, tenatato katoa.
Kia ora koutou, everyone. It's my great pleasure to welcome a long-term colleague and friend, Professor Margaret Briggs, to give her inaugural professorial lecture. Professor Briggs is a proud graduate of the University of Otago and holds a Bachelor of Laws with first-class honours and a Master of Laws with distinction. Professor Briggs is also a Barrister and Solicitor of the High Court of New Zealand. Professor Briggs joined the Faculty of Law at Otago as a teaching fellow in 1987 and carried on as a tutor in 1988, where she also worked as a Barrister and Solicitor at the leading firm of Laidlaw, O'Driscoll and Marks. I'm sure you remember those days very fondly, Margaret. And in 1989, Professor Briggs returned to the faculty as an assistant lecturer and was appointed lecturer in 1993. In her time in the law faculty to date, Professor Briggs has shown that she is a highly accomplished and versatile teacher. Professor Briggs has taught in the areas of criminal law, crime and property, advanced family property and property law. She's well known amongst students and professional groups as a master of her subject matter and an outstanding teacher, with clarity of presentation, as you'll all find out tonight. Apart from teaching the law faculty, Professor Briggs is in high demand in professional international conferences as a speaker, and I've seen many of her presentations and enjoyed them all. Professor Briggs is internationally recognised and widely cited, as the Vice-Chancellor said, in two distinct areas of academic research, criminal law and family property. In criminal law, Professor Briggs is widely known and widely cited for her work, particularly in the areas of the law of attempt, which we're going to hear about tonight, officially induced area, and in property crimes. In the area of relationship property, Professor Briggs is part of international collaboration established at Cambridge University, which is doing an in-depth study into the future of registered partnerships. Professor Briggs has also written extensively on many aspects of relationship property, including the types of relationship property that should be included within the concept of relationship property, the types of the classification and division of relationship property, how debts and relationship property should be dealt with, and the increase in value of separate property. Professor Briggs' research has been published by internationally renowned publishers such as Thomson Brookers, Thomson Reuters, Insentia Cambridge, Hart Publishing Oxford, and is also in highly published and significant academic law journals such as the Common Law World Review, New Zealand University's Law Review, and New Zealand Law Review. In both fields, Professor Briggs has been widely cited by international academics in the common law world, as well as widely cited by the New Zealand courts. Professor Briggs has also done a wide range of significant service activities. As the long-term and the longest-serving editor of the Otago Law Review, the flagship of this faculty, since 2005, Professor Briggs has been the overall editor. The Otago Law Review, as you'll know, is highly ranked in the world as a journal, thanks to the dedicated work that Professor Briggs has done over many years, ensuring only high-quality peer-reviewed articles are published in the journal. It's high-quality work, Margaret, and you do it quietly and efficiently, and it should be noticed tonight. Professor Briggs has been a member of the University Ethics Committee since 2010. She's currently a member of the Humanities Division Graduate Studies Committee. She's also serving the Humanities Division Research Committee and has served on numerous faculties committees with distinction, always giving a wise word in any committee she serves on. So, Professor Margaret Briggs, it gives me the greatest of pleasure, and I'm sure it gives everyone else here the greatest of pleasure, to invite you tonight to give your inaugural professorial lecture on a topic I know that's close to your heart, criminal attempts, how close is too close. Please give Margaret a big welcome.
Can you hear me? Thank you. Vice-Chancellor, Professor Hennigan, thank you very much for that fulsome introduction. However, I am reasonably certain that I have yet to meet the person that you have just been describing. Unfortunately, in her absence, I'm afraid that you may have to make do with me this evening. So on that cautionary note, I will begin. The invitation to deliver this lecture is accompanied by a list of guidelines, one of which is that we trace our research journey from whence we began to where we are now. For me, as you have already heard, that journey first began when I was an undergraduate student at this law faculty in the 1980s. Even then, two areas of the law were of particular significance and interest to me, and they were criminal law and family law, or more specifically, the relationship property aspects of family law. And you might ask, well, why those two disparate areas in particular? Well, I suppose I've always been drawn to those sorts of legal relationships where there is the whiff of a power imbalance, where there is a disadvantaged party pitted against a party who holds more of the bargaining chips. And although we might say that power imbalance is a predictable feature of most parts of the law, it is pronouncedly the case in criminal law and also to a fair degree in family property law. My curiosity in those two subjects was sparked when I was a student by two lecturers in particular, Mark Hennigan, who taught and continues to teach family law, and Professor Kevin Dawkins, who until his retirement earlier this year taught criminal law. And it was clear to us as students that they both possessed encyclopedic understanding of their disciplines, and in their very individual ways, they conveyed to us an evangelical zeal for what they taught. And so I was an easy convert. Maybe not on the road to Damascus, but Vice-Chancellor, next best thing, banks of the Leith. So after graduating, as you've heard, following a very brief stint in practice, I returned to the faculty And to cut the story short, I've never left. And in the time I have been here, I really do regard myself as fortunate to have been able to pursue my dual research interests in criminal law and family property law. And along the way, I have had the privilege of working alongside many inspirational colleagues, many of whom are here tonight. So now to my explanation for my choice of topic for this lecture. When I returned to the faculty in 1989, the first block of teaching ever assigned to me as an assistant lecturer was in criminal law, and it was on the subject of the crime of attempt. And preparing those lectures opened my eyes to the wide range of conceptual and really largely intractable challenges raised by attempts. So much so that this facet of the criminal law has become one of my enduring research interests. So out of all the things I could have talked about this evening, I have decided to take you back to my very roots and tell you how one microcosm of the law of attempt has evolved since I first became interested in it all those years ago. And so now to the main course. Well, the criminal law is engaged in a great many line drawing exercises. And one that can present real challenges is locating the point at which a person's conduct passes from mere non-criminal preparation to a fully fledged attempt to commit an offence. The law does not, as a general rule, criminalise a person's early acts of preparing to commit an offence. But if those acts get close enough to the full offence, they are said to be an attempt, and attempts are criminalised. So identifying the minimum conduct for an attempt is therefore crucial because it marks the first point at which a person can be held responsible for their actions. Now, of course, in many cases, there is no problem at all in identifying a fully fledged attempt. So, for example, the actor who fires the gun with murderous intent, but who misses or merely injures the victim is clearly guilty of attempted murder. But the cases that cause the problems are those where the actor's conduct stops short at some earlier point in time. The current statutory formulation of what amounts to a criminal attempt is found in section 72 of the Crimes Act. And from that provision, we can determine several things. First of all, from subsection 1, we can determine that in order to be guilty of an attempt, the person must first of all intend to commit the offence, whatever that offence might be. It might be theft, it might be kidnapping, it might be murder, and so on. But in addition to that intention, we are told that the person must also do an act for the purpose of accomplishing their object. Secondly, subsection 2 tells us, however, that not all acts will qualify. Acts that are merely preparatory are described as too remote to constitute an attempt, and we're also told that that is a question of law for the judge to determine. Thirdly, we are told that acts that are immediately or proximately connected with the intended offence may constitute an attempt. Now, those words, immediately or proximately connected, in subsection 3, suggest that the conduct must be fairly close to the full offence, whether in terms of time or physical location or both, we are not told, but the implication is clearly there that the actor's conduct ought to be somewhere in the home stretch. Lastly, if we combine the wording of subsections 2 and 3, we can tell that a line is to be drawn between non-criminal preparation and a criminal attempt, but we are not told where exactly to draw it. And that is where the courts must provide us with judicial insight into the words of the provision. Historically, however, no single judicial gloss has coped particularly well with the very complex matrix of different offences and different fact scenarios that have come before the courts. And so finding the dividing line in any given case can depend very much on the type of offence involved and what the acts are that the defendant is alleged to have committed. So, for example, an attempted fraud will comprise a very different set of steps to an attempted murder. But of course, abstract talk takes us only so far. And so I'm now going to outline 4 cases which I hope will demonstrate the changes that have taken place in the law of attempt in the time that I have been researching in the field. Until 2010, the 1982 Court of Appeal case of Wilcox had dominated the attempt landscape and judicial thinking about attempt in New Zealand for almost 3 decades. And this was certainly the case that I cut my teeth on, both as a student and when I began researching and teaching in the area. Wilcox concerned an attempted aggravated robbery of a post office. Wilcox and his accomplices had performed a number of acts in pursuance of their plan. They had made several purchases. They had purchased balaclavas with which to conceal their identities, and they had purchased some air rifles and pallets to point at the unfortunate bank staff. They had then loaded the rifles and set off in a car towards their destination, which was about 3 miles distant. However, the police, who had been informed about the plan, stopped the car when it was about 1 mile from the post office. Now, the deceptively simple question in that case was, when those men were stopped in that car, had they done enough to amount to attempted aggravated robbery? Or to put it another way, were they already committing an attempted aggravated robbery when they were stopped? Now, were I to ask you for a show of hands, I'm not, but were I to ask you for a show of hands on that question, I suspect that there would be no unanimity among you. On the contrary, I think that you would hold a range of different views on where the preparatory steps finished and the proximate conduct began, if at all, on that 3-mile journey. Well, what did the court think in this case? Well, the Court of Appeal held that Wilcox's actions had not gone beyond preparation. So that means no attempt. And the court made a number of significant findings. It said that when the police stopped the car, the men were doing no more than getting themselves to a physical location close to the post office from which an attempt could then be launched. In other words, there was as yet no commencement of execution or step in the actual commission of the crime itself. And the court also said that it was important to give separate consideration, first of all, to the men's intention to commit the crime, and secondly, to the physical actions that they had done in pursuance of their intentions. So then, even if there is proof of a person's bad intentions, they may not yet have performed enough significant actions to translate those intentions into a fully fledged attempt. The Wilcox reasoning was applied regularly in subsequent decisions, and for some time I assumed that this part of the law of attempt was fairly settled and reasonably dormant. But Wilcox did not find universal support, and there were occasional rumblings that the approach was somewhat artificial, rather too defendant-friendly, and could result in the police having to wait until matters had reached a dangerous stage. And the first warning signs of an impending change came with the case of Burritt, where the High Court judge was openly critical of Wilcox. Now, Burritt was decided in 2003, and some of you may even remember the case hitting the news headlines at the time. And the photograph on the slide is a photograph of the protagonist, Mr. Burritt, and I think it is possibly a photograph of himself leading his own defence in the trial in court. The case concerned, and this may start ringing some bells, the case concerned the attempted kidnapping of a wealthy Wellington businessman, later revealed to be Bill Trotter, son of the former Fletcher Challenge chairman Sir Ron Trotter. And the would-be kidnappers had gone to some considerable lengths to accommodate their special guest. They had dug an underground bunker of no small proportions for him in the Remutaka Forest Park. And they were planning to hide him in that bunker until the Trotter family paid some outrageous ransom. And they were not entirely insensitive to his plight. They had provided him with a modicum of home comforts. They had equipped the bunker with an ensuite and an air ventilation system. And they had stocked it with various pantry items, including Lindau Bubbly and Griffin's Crispy Biscuits, no doubt, lest he should feel like having a little solo celebration while down there. And that first slide there that you will see is a pan shot of the bunker. To the left, you will see the rather rudimentary toilet. To the right, which is to the right at the upper corner, is the air ventilation system. And you will not see the writing on the wall, but I will read it to you. It says, "Welcome to your new home. Maximum stay 6 days. We will not hurt you." And they even thoughtfully provided, they rather thoughtfully provided instructions on how to operate the ventilation system, lest he suffocate. And they did not get their ransom. However, their plan was never put to the test because their efforts were in vain, because the police had discovered what was happening and they had been watching the men for several days before arresting them on the day of the attempt. And the police caught them near the entrance to the Wellington Botanical Gardens, just a few hundred metres from the victim's home, where they were going to grab him. Again, as in the first case, Wilcox, the question was whether they were in the throes of an attempted kidnapping when the police stopped them. Well, Justice Hammond reluctantly concluded that the conduct was merely preparatory, and he reluctantly applied Wilcox, but he noted, were it open to this court to start afresh, he would have preferred to view proximity as a relative matter. It might vary in its importance, having regard to the strength of such other evidence as there is, as to the purposes, and by that he meant the intentions of the accused. But he said regretfully, that did not represent the present law in New Zealand, and that was in 2003. However, the Court of Appeal in the next case of Harper in 2010 grasped that opportunity to start afresh that was alluded to in Burritt. And as a side point, the judge in Burritt, Justice Hammond, had been promoted to the Court of Appeal by the time of Harper and was indeed one of the 5 presiding judges in that case. Harper heralded a new way of approaching the question of proximity. Harper, and you'll be pleased I don't have photographs for this case, Harper was charged with the attempted sexual violation of 2 children. He was in a text messaging relationship with an adult woman and sent her a video and text messages indicated that he was involved in abusing children. Under police guidance, the woman arranged to meet Harper, telling him that she would bring her 10-year-old sister and 4-year-old niece with her. Unbeknown to Harper, neither child existed in fact, and I'll come back to that in a moment. Harper was waiting when a car driven by a female police officer arrived at the arranged meeting place. Now, you might be wondering about the non-existent children. Well, they are irrelevant for the purposes of the crime of attempt. Section 72, the attempt provision in the Crimes Act, says that as long as the person has the intention and has done proximate acts, it does not matter if it was impossible for any reason to commit the offence. So impossibility is generally no defence to a charge of attempt. Yet another riddle in the law of attempt, but one that we don't have time to look at tonight. So you'll just have to trust me on that one, counterintuitive though it may be. Again, the question in Harper was whether the acts were proximate. And this time, the Court of Appeal said yes. And it held that Harper had performed a number of acts which, when taken together, constituted an attempt to commit sexual violation. He had moved beyond mere preparation, and at the time of his arrest, he was lying in wait for the victim. In the court's opinion, Section 72 permitted the defendant's conduct to be considered in its entirety, with effect that strong evidence of intent, as there was in that case, can assist in assessing the significance of the acts done towards the commission of the intended offence. And of course, Harper's explicit text messages revealing his intentions towards the putative victims was an essential factor in deciding the proximity of his actions. Now, the court said that rather than trying to invent a new test of proximity, the direct purpose of its ruling was simply to reassess Wilcox, which it held had been wrongly decided on the facts. However, the legacy of Harper is, I think, rather more pervasive than that. It has rather created a new precedent for looking at matters in the round, where strong evidence of intention can now assist in assessing the significance of the actions done toward the commission of the offence. And this is the first time that we see the actor's mental state, their intentions, overtly used to measure the quality or the significance of the acts done. And that is quite a shift from the old Wilcox approach of compartmentalising intentions on the one hand and actions on the other. But Harper left one matter unresolved. Exactly what the court meant by strong evidence of intent didn't need to be explored in that case, because on the facts there was ample evidence of Harper's intention in those text messages. But not all cases are going to be that clear. And the final case in this quartet takes Harper one step further. And it demonstrates that the courts seem to be prepared to give a broad reading of what amounts to strong evidence of intent. In Johnson, the father of the 16-year-old complainant found the defendant lurking in the backyard of the family home, a few metres from a detached sleep-out where the girl slept at night. It was early evening. Johnson was wearing dark clothing. He was carrying a torch, and there was evidence that he'd been watching the house for some weeks prior to the incident. On the basis of that, Johnson was charged with attempted rape. Now, the case made its way to the Supreme Court last year, which agreed with the Court of Appeal that Johnson's conduct did amount to attempted rape. But unlike Harper, this time there was no direct evidence of Johnson's intentions, because Johnson argued throughout that he was there to commit a property burglary, not rape. However, the courts had allowed the Crown to introduce something called propensity evidence to establish, or help establish, that Johnson was on that property with the intention of committing rape, not burglary. Now, propensity evidence is evidence that tends to show a person's predisposition to behave in a particular way. And the evidence that was admitted in that case included 2 rape convictions in the 1990s, and the evidence of a fellow prison inmate and a halfway house flatmate regarding conversations that they had had with Johnson about his obsession with teenage girls. The Supreme Court unanimously confirmed the approach taken in Harper, that evidence of intention is relevant to determining whether the defendant's actions are proximate. And the court says this does not turn mere preparation into an attempt. Rather, it is recognising that where clear intent is shown, the decision maker has a basis to determine whether the conduct is more than mere preparation. And the court considered that Johnson's presence on the property and his movement toward the sleep-out could not be assessed in terms of whether it was preparatory or proximate without considering the evidence of his intent to sexually violate a teenage girl. Evidence, remember this time, obtained via propensity evidence. So, in conclusion to this first part of the talk, what seems to be emerging is a rather more loosely textured test of proximity than the more compartmentalised or segregated test used back in the days of Wilcox. And I would suggest that this new, if you like, global approach does provide the opportunity to push the dividing line back further in certain cases. Evidence of intention, remember including propensity evidence, can now be used to reinforce the conduct component in those cases where a close line call is required. What then should we make of these changes? Well, not just the law of attempt, but the criminal law in general terms, including multiple aspects of policing, criminal procedure and sentencing policy, has changed markedly since I first began researching in the area. And some of the more visible and more consciously targeted changes over that time have been the concerted political efforts to get tough on crime. And this, of course, has resulted in a number of things, such as enhancing police powers to respond to crime and threats of crime, tightening bail, reducing parole, increasing sentences, and giving victims of crime more of a voice with the enactment of the Victims' Rights Act in 2002. And the list goes on. And these are very positive moves, because for a long time, the criminal justice system has been criticised as being out of touch with community attitudes towards crime and punishment and the victims of crime. And judges, especially sentencing judges, have been the focus of particular criticism as an unelected cultural elite that is out of step with the wishes and expectations of the community. And so the interpretation of Section 72 in the 2 recent attempt cases of Harper and Johnson is symptomatic of this generally more policy motivated and sometimes less defendant-friendly stance that we have generally seen emerging in recent years. And this is a natural response to perceived threats to our safety, which always seem to be on the increase, as again we've recently seen in the news, and never on the decrease. And of course the defendants in such cases are quite unsympathetic characters whom we rightly regard as deserving of censure. And so, for example, the defendant in Johnson had a very disturbing criminal record stretching back many years, and charging him with attempted sexual violation had the practical advantage that if convicted, he could be sentenced to preventive detention. So then there is a very persuasive argument that practical or policy considerations directed at the public good rightly outweigh matters of strict doctrinal principle in such attempt cases. But should they? Should we simply accept this trend, or should we at least subject it to some scrutiny? Don't forget that by buying into the tough on crime brand name, just as we may reap advantages, we also run the risk of diluting our own rights. And the recent developments in attempt demonstrate the very important gatekeeper role played by the courts. But whether the right balance has now been achieved is, I would suggest, at least open to debate. In order to assess whether the right balance has been achieved, I think we need to go back to first principles and ask why it is that we treat an attempt to commit a crime as a crime in its own right. Well, the most obvious answer to that is that it helps prevent harm, or at least more serious harm, from happening. So conduct leading to the commission of the full crime is therefore a legitimate target, because that conduct risks completion of the full offence. And the police require the legal mandate to step in and prevent an actor who is on the way to committing a crime from going any further. So, as the old proverb says, an ounce of prevention is indeed worth a pound of cure. There are two theories about the law of attempt, which help explain why the courts sometimes lean in favour of the prosecution and sometimes lean in favour of the defendant. And the first of these is the subjective theory, which places emphasis on the intention element of the offending. So criminal liability is primarily assessed on what the individual intended to do, rather than the actual consequences of their conduct. And so this nip-it-in-the-bud approach is designed to ensure public safety as far as possible, and it therefore justifies imposing liability at an earlier and more remote stage from the full offence. Contrast that with the second theory, the objective theory, which focuses rather on the defendant's conduct and imposes liability generally at a later stage once the defendant is physically close to committing the crime. Now, objectivists tend to require a manifest threat to the security interests of others, and they place importance on the preservation of individual freedom unconstrained by police and judicial interference. And Wilcox is an example of that more defendant-friendly objective approach. And in that case, the court placed a lot of emphasis on the physical steps that the defendants had not yet performed when they were stopped 1 mile from the post office. The difficulty is that both sides of the argument are, of course, susceptible to extremes. An overly rigid objective approach leads to only the last step or steps counting as an attempt. And delayed intervention, of course, risks unjustified harm to individuals or property and leaves the police and the judiciary vulnerable to criticism from the general community. But equally, if the subjective approach is pushed too far, there is a valid concern that overly zealous intervention can risk punishing people who have done little more than form criminal intention. Now, in New Zealand, the pendulum has recently swung in favour of subjectivism, with Harper and Johnson placing emphasis on the defendant's intentions. Looking to the future, We therefore need to be wary of that approach being pushed too far. For example, a potential concern might be that actors who have voluntarily abandoned their plans of their own accord could be deprived of making that claim if the subjective preference for the emphasis on the actor's intention is pushed too far. And there is always a worry that in persuasive enough hands, almost any conduct could be made to appear guilty in the presence of strong enough evidence of the defendant's intentions. Now, that is not to detract from the fact that both Harper and Johnson involved allegations of disturbing intentions on the part of the actors. And so it's hardly surprising that the courts gave added weight to the need to step in quickly to prevent harm to the putative victims in those cases. And of course, it's not difficult to identify other contexts, such as cases of suspected terrorist activity, for example, where there are equally strong arguments for nipping nascent criminal activity in the bud as soon as possible. So then, on an individual basis, the ends might appear to justify the means, particularly when sensitive or security issues are at stake and public opinion runs high. But whatever we might think about the ultimate justice of outcomes in cases like Johnson, the reasoning does take the wording of Section 72 in a new direction. The express words of Section 72, immediately or proximately connected to the intended offence, which were once the critical marker of an attempt, are just not as centre stage as they once were. So, to the final part of the talk, the question then becomes, is there a solution? Well, that's the case, isn't it? I preface the following comments with the caveat that the law of attempt is one pocket or corner of the criminal law that is likely to be written off, as I would describe it, as an unrequited Goldilocks. Whatever test or gloss is devised, it's always going to be too hard, too soft, and never just right. You are never going to please all of the people all of the time, or indeed most of the people any of the time. So we're really in a catch-22 in this part of the law. Now, of course, advocates of this new global approach of looking to the person's intention to tell you whether their actions are proximate enough, they would argue that no solution is required because there is no problem. On the contrary, they would argue that the courts have at last located an appropriate interpretation of the statute. Others, however, might suggest that we should at least be looking for a more doctrinally satisfying solution that avoids, if I might borrow the words of Dennis Denuto in the film The Castle, an answer based largely on the vibe of the thing. Conservatively, it is possible that a wait-and-see approach is all that is needed, and that future cases will tease out a more nuanced approach, or perhaps confine Harper and Johnson to like offences of sexual offending. Or maybe that future cases would even reconsider the use of propensity evidence as a means of getting traction on intention. Another option might be for Parliament to take another tilt at the attempt section in the Crimes Act, although I have no great faith that that would amount to much more than tilting at windmills. Amendments to equivalent attempt laws in comparable overseas jurisdictions have simply not achieved the desired clarity. Or maybe we're simply looking at this problem from the wrong angle. If we accept that there are cogent policy reasons to allow the police to step in at an early stage where proximity in the traditional sense of that word is still doubtful, then the issue is surely whether attempt continues to be the right offence and the appropriate label for the sorts of conduct that we deem worthy of punishment. If so, then classifying the defendant's actions as an attempt is actually to mislabel what has thus far taken place. Might it not then be more appropriate simply to acknowledge that the law is justified in criminalising certain preparatory activity and simply relabel it accordingly? The actor's conduct would still be recognised as a threat requiring preventive intervention, but not to the same degree that it would have been had the conduct reached the stage of immediate or proximate connection with the intended offence. A penalty reduction would recognise that the actor had taken fewer steps towards the commission of the full offence, and that preparatory conduct is indeed not the equivalent to a full-blown attempt. An offence of preparation would satisfy subjectivist concerns by recognising the social utility of stopping the actor at an early stage in order to prevent harm being done. But it would also satisfy the requirement of giving individuals due notice of what not to do in order to avoid criminal sanction for a particular offence. And all of that would mean that the attempt label would not need to be overextended and could be reserved for activity of a genuinely immediate or proximate nature. And I should perhaps mention that the idea of offences of preparation is not entirely without precedent. For example, New Zealand criminal law currently recognises a number of preparatory offences in specific areas. So, for example, the misuse of drugs legislation prohibits the supply, production or manufacture of precursor substances. The Arms Act prohibits the carrying of a firearm with criminal intent. And there are various offences of a preparatory nature in the Terrorism Suppression Act. However, I fully accept that it would be naive to suppose that a general offence of preparation would be free from problems. And the most patent objection would be that the current concerns about locating the borderline between preparation and proximity would simply be replaced by the problem but one step back. And there is a risk that a general offence of preparation could be interpreted as an invitation to extend liability further and still further back. And critics of that approach would argue that this solution would risk normalising criminalisation at an even earlier point in time. So another impasse, maybe, and yet again we go round in circles. And so I suspect that this attempt puzzle is not done with me just yet. So in conclusion, all of this puts me in mind of a passage from Lewis Carroll's Through the Looking Glass, which I will leave you with this evening. And it's where Alice is talking with the Queen and asks her what sorts of things she remembers best, to which the Queen replies, things that happened the week after next. The Queen then told Alice about the King's Messenger, who was in prison, being punished, and the trial doesn't even begin till next Wednesday, and of course the crime comes last of all. Suppose he never commits the crime, Alice asked. That would be all the better, wouldn't it? Replied the Queen. Alice felt there was no denying that, but replied, but it wouldn't be all the better his being punished. You're wrong there at any rate, said the Queen. Were you ever punished? Only for faults, said Alice. And you were all the better for it, I know, the Queen said triumphantly. Yes, but then I had done the things I was punished for, said Alice, and that makes all the difference. But if you hadn't done them, the Queen said, that would have been better still. Better and better and better. And her voice went higher with each better till it got quite to a squeak at last. And Alice was just beginning to say, there's a mistake somewhere, when the Queen began screaming so loud that Alice had to leave her sentence unfinished. And for fans of Lewis Carroll, you will recall why the Queen was screaming so loudly. It was because her finger was bleeding, even though she had yet to prick it. So I think that is more than enough rabbit holes for one evening. Thank you for your attention.
Tēnā koutou katoa. My name is Tony Ballantyne and I'm the Pro-Vice-Chancellor of Humanities, and it's with great pleasure that I'll deliver a vote of thanks to Professor Briggs. Margaret has delivered an excellent lecture, reflecting on the development of her research and teaching. It all began, as Margaret told us, with a conversion here by the waters of the Leith, where the enthusiasm and knowledge of Mark Hennigan and Kevin Dawkins had transformative power. And those reflections, I think, Margaret reminds us just how important our work as teachers is and how transformative great teaching can be. And then again, in the lecture itself, she's role-modelled the lecture form. Of course, the primary focus of her talk this evening has been the law of attempt. She recounted that this was the subject of her first block of teaching here as an assistant lecturer. So we've come in a full intellectual circle. But she also observed that this has been an abiding and consistent interest throughout her career. And I think, again, this reminds us of the important feedback loop that exists between teaching and research, and that is something that our university really values very highly. As we've heard, her lecture used 4 cases to trace changes that have taken place in the law of attempt from 1982 through to the 2010s, particularly the increased weight attached to the actor's mental state as evidence of intent. A shift, as Margaret has suggested, was a key element in a move to a more global or holistic approach to interpreting these questions. This evening, Margaret carefully explored the ensuing question: did these shifts get the balance right in assessing the borderline between preparation and attempt? While she acknowledged that the law of attempt is difficult to test, for some, any such assessments will either be too hard, while for many others it will be too soft. But she then provided an alternative way forward, asking whether attempt continues to be the right offence and whether, in fact, it is an appropriate label for the sorts of actions that the wider community wants to prevent or to punish. And she has suggested that exploring the possibility of offences of preparation might be a constructive way forward, with the caveat that this is a very difficult legal puzzle to solve. I think Margaret's lecture has been incredibly thoughtful and engaging. Most of all, it has demonstrated the great social importance, I think, of legal thought and practice in establishing the rules that we live by and how we interpret and enact those rules as a society. So I'd like to invite you all to join the academic party for refreshments in a moment across the hall. But right now, I'd like to invite you to thank and recognise Margaret for a fantastic lecture and to celebrate her promotion while I give her a small token.